You know, legal warriors, we get this question all the time in my office. Can my felony charge get dismissed? Felonies are serious. Is it possible to get a felon dismissed? Well, sometimes the answer is yes. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. I'm just going to jump right into it. Can a felony charge be dismissed? And the title of this video is an ex-prosecutor talks about how felonies can get dismissed. And I was a prosecutor for 7 years. I've been doing defense for more than 20. So I've seen plenty of cases in my time. So what is a felony charge? A felony charge is something where the maximum penalty is more than a year in jail. So a serious assault, a sex offense, offenses with guns, serious thefts more than a certain dollar amount, pretty much, half or more of the possible crimes out there are felonies, depending on what happens. Burglary, robbery, breaking in places, anything you might imagine. So drug cases often are felonies. So what's the difference between a felony and a misdemeanor? Well, the misdemeanors are stuff like theft, low-level theft, DUI, hit and run, and those aren't usually taken so seriously because of the volume. Those might be easier to get dismissed. So how can you get a serious charge dismissed like a felony? Well, I can think of many different ways. I'm going to say there's 5 different ways that we can get a felony dismissed. And what's the obvious one? Well, the obvious one is trial, right? We take our case to trial, and the state is unable to prove their case beyond a reasonable doubt, right? The state has to prove every element of the crime beyond a reasonable doubt. And so if they have a witness fail to appear, a key witness like a victim in a domestic violence case or a sex case, if they have evidence that's been corrupted, right? Bad DNA evidence, bad search and seizure things, then the jury may not have enough evidence to convict someone. In fact, the prosecutor might have to dismiss the case at trial if nobody shows up. So one way is trial. What's the second way? Motions, right? Especially in a possessory offense. So you're charged with drugs, or you're charged with possession of stolen property. Is someone charged with something where they need that key piece of evidence to prove guilt? Well, if the officers involved did an illegal search, an illegal seizure, they needed a warrant, they didn't have one, they lied on the warrant, many ways that we can challenge the search and seizure. A bad stop on a felony DUI or a vehicular homicide. Maybe it was a bad stop. Maybe they can't, maybe they violated Miranda rights and that confession was key. And without that confession, the state cannot proceed. So a second way to get cases dismissed is by motion. What's a third way we can get a case dismissed? A third way would be negotiation, right? Negotiation. We recently got a second-degree assault dismissed in my law firm by negotiating without having to go all the way to a trial. So your attorney may be able to actually gather evidence and try to show the prosecutor what's wrong with their case. And remember, if you watch this channel, if we're gathering evidence, we should also be doing some other things, especially on an assault case in this example. We want to be doing some classes and some things to show that we're changing our ways. And so, hey, it's a hard case to prove, but prosecutor, we've done some stuff, so why don't you dismiss the case? Negotiation. There might be a theft of mail case, right? It could be a theft of mail case where, the case isn't so serious and the client has done a bunch of drug treatment that led to the theft of mail. And maybe they can't, they have so many cases going on that they can't take them all to trial. So they might dismiss that case, even though they could prove it because the client has no record. The client's done a bunch of drug treatment that led to the theft of mail, typically if people are out there stealing stuff like that. And they just don't have the man or woman power to prosecute. So I think the third way would be negotiation. The fourth way, it would be programs. Alternative programs. What are the alternative programs that are out there? And this one people forget about, okay? Depending on what county you're in Washington State, there could be a drug court where we do drug treatment for a period of time. And if we successfully do it, we get a dismissal of our case. It's hard to go through, but it can work. There's also going to be things like adult diversion. Snohomish County has a couple different adult diversion programs nowadays. So congratulations, Snohomish County. There's therapeutic alternatives to prosecution and another adult diversion program where if you don't really fit into that, but basically some places will say, hey, if a low-level felony, not a crime against a person, a property crime or something like that is caused by mental health issues or drug issues, then perhaps you can get entered into the program. It might take years, but if you successfully complete what some counselor or somebody wants you to do and you stay out of trouble, you can earn a dismissal of your case through alternative programs. And each county has different ones. There could be all different types of diversion programs, and that also can apply to juvenile cases as well. Some juvenile cases will be some programs. Number 5. What's number 5? And number 5 is specifically for juvenile court. There's actually statutory ways that you're entitled to get a dismissal under some types of felonies, especially juvenile court. There's something called deferred dispositions in juvenile court, and I have a video called Deferred is the Word that talks about all the different types of deferrals. But in juvenile court, in certain types of cases, you can plead guilty and go through certain things, get your disposition deferred, and then statutorily earn a dismissal, not discretionarily. And number 4, those other programs are discretionary with the prosecutor, right? They don't have to put you in them. They don't have to exist. But there are some situations, especially in juvenile court, where you can statutorily earn a dismissal in certain circumstances. Okay, it has to be granted by the court, but the prosecutor can't do anything about it once the court grants it. So those are 5 different ways you can get your felony case dismissed. If you can't get the case dismissed, a little bonus section here, what can you do? Well, getting a felony reduced to a misdemeanor, that's way better than a felony, right? You can also sometimes get a prosecutor to reduce a felony to a misdemeanor. Felonies have, for the most part, determinate sentences between certain ranges, so the judge doesn't have a lot of discretion, and the prosecutor has a lot of power, because if they add more charges, it ups that range, okay? If it gets reduced to a non-felony, then the judge has total discretion. They can go all the way down to 0 if they want. They don't have the lower end limited like they do in most felonies. Also, if you're convicted of felony, you're going to lose your gun rights, you're going to lose your right to vote. For most misdemeanors, that's not true. We just did a video about a second offense DUI. Now you lose your gun rights, which is crazy. And also on domestic violence convictions, many different domestic violence convictions, you can lose your gun rights. So those are 5 ways you can get a felony case dismissed here in Washington State. I'm sure some people out there can think of some other ways. You can put it in the comments. The most risky way is the trial, right? If you go to trial, which you have a right to, the prosecutor's usually going to put every possible charge they can on you to discourage you from going to trial. That's going to up your standard range. So although I listed it first, it's probably the least preferred way. But unfortunately, in felonies, it's probably something we have to do, because on more serious charges, we're not going to get into these other programs. The prosecutor's not going to offer discretion. Sometimes we can negotiate our way out, but usually it's going to be trial if it's a very serious charge. So I hope you found this video useful. If so, please like and subscribe. It's not hopeless. It is not hopeless if you're charged with a felony. It's a hard situation, but I want you to hang in there. And if you have a legal problem here in Washington State, feel free to give us a call. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.